So we are excited and very happy to have Brian Dittmeier back. He is the Director of Public Policy at GLSEN, where he works to advance safe, affirming, and inclusive learning environments for LGBTQI plus youth. Brian has more than a decade of experience advocating for civil rights and human needs protection improvements, working to secure new and strengthen federal civil rights protections in education and employment settings, new investments in federal assistance programs, for low-income families and more robust state-based supports for LGBTQI plus youth, immigrant families, and survivors of sexual violence. In 2021, Brian served as the inaugural advocacy chair for the LGBTQ plus Anti-Poverty Action Network, working in partnership with across movements to develop a cross-sector policy agenda for the new administration. And he is based in DC, but I believe he is not actually in DC tonight, so a little more rural. But we're going to kick it over to Brian, and do you want me to start sharing slides?
Yeah, thank you so much, Julie. And Julie, it is great to be here with this community. What a fantastic lineup of events you have. Red, White, and Royal Blue is a personal favorite of mine as well. So please enjoy the book, and very happy to be here with this community. This is not my first presentation to Red, White, and Blue. And I know that each and every one of you is so dedicated to moving forward justice in your communities. And I'm looking forward to sharing some opportunities here as well, where perhaps we can partner. And specifically, when it comes to creating safe environments in our schools, we know there are so many issues that are percolating at the federal, at the state, and particularly at the local level. We even just in the list of events, when it comes to book bans and it comes to censorship and curriculum, we've been struggling in not just in the LGBTQ community, but when we think about discussions about race and racism, about gender roles, to really breaking through in making sure that the next generation has access to lessons that are rooted in the diversity of this country. And so that's why it's so important that we take moments to reflect on what protections we have available and what actions we can take to build those safe, affirming, and inclusive learning environments for our youth. I'm here today specifically on behalf of GLSEN to talk about Title IX, some recent changes that have happened around rules about sex-based harassment and discrimination in schools, and what this means for the months and months ahead as well. As Julie mentioned, I'm here on behalf of GLSEN. GLSEN originally stands for Gay, Lesbian, Straight Education Network. We have worked for 3 decades to draw attention to bullying and harassment issues in schools, particularly how it affects LGBTQ students. We originally founded by educators in New England who looked around and saw this persistent harassment and bullying happening and thinking, how can we partner both as members of the LGBTQ community, but also as allies to change behaviors and attitudes? And since then, it's become a network not just of educators, but also of students, parents, and community voices that are helping to move forward change in communities. And one of the biggest changes has been recent updates to Title IX. And so we're going to talk a bit about how that impacts not just LGBTQ youth, but all students. And as you can expect, it's faced some significant resistance from certain school officials and certain politicians who are seeking to undermine inclusion in schools. And that is exactly why we all need to be standing up in this moment and speaking out. When we think about inclusion in schools, there's a lot of different connections of how we can frame that conversation. So when it comes to LGBTQI youth in particular, but also thinking more broadly to students who are facing marginalization, who are facing victimization, there's different impacts that really affect their well-being. And so we can have conversations about academic achievement, closing the achievement gap. That's been a big conversation coming out of COVID-19 and the disruptions in school. But we know that when a student is facing bullying in school, they're not going to be paying as much attention to their grades. And so they'll face lower GPAs, they'll face lower likelihood of wanting to pursue post-secondary education. And that not only impacts their academic achievement, but their economic mobility for years and decades to come. Another big conversation is around reducing absenteeism, right? So if a student is being bullied, they are not going to want to be in school. They're not going to want to show up in their school community. And we've seen higher rates of absenteeism when a student is facing victimization in school. And that ties in with school belonging. How invested are they in the community, and how validated do they feel in that community? Then we can think about mental health outcomes. When a student is being bullied or victimized in school, and particularly over your period of time, we see higher rates of anxiety and depression, and unfortunately, higher rates of suicidality. And that crosses populations as well. It's a startling statistic, and one that I often start with, is that suicide is the second leading cause of death for 10 to 14-year-olds across the board. And when we're talking about the LGBTQ population, LGBTQ youth are 4 times more likely to consider suicide than their straight and cisgender peers. And so those are really alarming statistics that are consistent with our understanding of a youth mental health crisis, particularly coming out of COVID-19. And so it's incumbent on all of us as community members, but as parents, as educators, as folks invested in the school community, to think about how do we build mental health supports, and how do we address some of the challenges in schools that really impact the well-being of youth. GLSEN has for several decades, and especially in a vacuum where the federal government is not necessarily collecting relevant data, we've surveyed LGBTQ youth, and this information has helped provide one of the clearest pictures of how LGBTQ youth feel about their school. And so our most recent survey was in 2021, which, as we all know, was in the middle of the COVID-19 crisis, and at the very beginning of this most recent wave of anti-LGBTQ policies, and frankly, anti-inclusion policies that we've been seeing push from groups like Moms for Liberty and the right wing. And so in a survey out of 22,000 LGBTQ youth, we've seen that there's staggeringly high rates of victimization, which includes being harassed, bullied, or even assaulted in school settings. 83%, more than 4 out of every 5 LGBTQ youth, reported being a victim of some form of harassment or assault in school. And what is particularly challenging is that we've seen that of those who were victimized in schools, 62% never reported an incident to school staff. And that means that we have a gap of trust between LGBTQ youth and school administration. A huge concern is that students felt that they would not be taken seriously, or that the school would be effective in investigating their victimization, but also a number of students, nearly half of students who never reported an incident, were fearful that they would be outed either to their parents or to their peers and the broader school community. And so that's a really challenging piece for us to navigate, because if there's such inherent fear in youth of sharing their identity, or even sharing that they are being bullied because they know the content of what the bullying is about may lead to their outing, then we are not able to provide the supports that they need to remedy this victimization. As we would expect as well, the most marginalized members of the community face even higher rates of victimization and isolation as well. And when we look at the LGBTQ community in particular, we're thinking about transgender and non-binary children, who also face not just victimization from their peers, but also discriminatory policies that target them in school settings. And so that could be a policy like a bathroom ban that does not allow a transgender student to access a bathroom that's consistent with their gender identity. Locker rooms, dress codes, all of these different policies that really impact how students identify and present, and their ability to be affirmed in their identity. What we see now is that there is a high rate of victimization and a high gap in trust between students and those who are responsible with making sure they have access to a safe learning environment. So if we move to the next slide, let's talk about what steps can be taken to address this gap of trust and help move towards a more positive learning environment. So for several decades, based on research, GLSEN has put forth 4 core supports, which I think should be relatively familiar, at least as concepts to all of you, as interventions that can help address all of those concerns we had at the beginning: academic success, sense of belonging, mental health outcomes. The first and foremost is having supportive educators. So not only making sure that kids feel validated in the classroom, but that they have examples and they have people who can nurture and support them to fulfill their full potential. Supporting student-led groups. And so in particular in the LGBTQ context, we have GSAs, which is gay, straight alliances, gender sexuality alliances. But across the spectrum of marginalized communities, there are different groups that can help empower youth to not only be with peers, but to be with people who support them and their experience. Inclusive learning is a bucket that I know all of you have been deeply invested in when it comes to having children see themselves reflected in what they're learning, as well as being able to learn about the great diversity in this country, both in the classroom, but also in areas of the school experience, like the school library, having the ability to access diverse materials, absolutely critical and important. And then the fourth and final piece, and this is really where it intersects with Title IX, is comprehensive policies, and particularly policies to address victimization and ensure safe school environments. And so that is the area where we're going to focus on tonight. Let's talk about Title IX for a moment. So Title IX was passed in 1972, and it's only about 35 words that are spelled out right here on the page. But I just want you to appreciate how broad the law is. No person in the United States, so note that it says person, not necessarily student, certainly not woman. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Incredibly broad statutory language. And so if we move to the next slide, there's been a long history in how this law, once it was passed over 50 years ago in 1972, has been expanded to really reflect the diversity of sex-based discrimination that students and others in the school community face. And there's been an kind of an entangling of how Title IX has been interpreted in courts with a law called Title VII, which is around employment. And so the big case that the mouse was hovering over just there is in 1989, Price Waterhouse versus Hopkins was an employment law case that determined that a woman who was denied a promotion because she did not dress like the partners expected a woman to dress, she did not act like the partners expected a woman to act, she didn't have makeup, she wore pants, all of these, flagrantly biased assumptions about what a woman should act and be like, constituted sex stereotyping that was unlawful under federal civil rights law. And that concept of sex stereotyping is so critical because it not just laid the foundation for protections around gender expression and defying the expectations put on both men and women about how they should act and dress and appear, but it also laid the groundwork for jurisprudence around sexual orientation and gender identity being folded into sex discrimination statutes. And so it was a long journey from that 1989 case to 2020, when the Supreme Court finally ruled that Title VII, based on the sex stereotyping doctrine, specifically prohibits discrimination in employment on the basis of sexual orientation and gender identity, in a famous case called the Bostock versus Clayton County case. Now, that happened in June of 2020. And since then, we've seen an aggressive pushback to LGBTQ inclusion in schools. And to an extent, that case being in Title VII should have been readily imported across federal non-discrimination laws. And so we should have seen Title IX, which discusses sex discrimination in education, immediately apply that logic. However, we've seen a very protracted campaign, a very targeted campaign to go after LGBTQ inclusion to essentially blunt the impact of this sweeping Supreme Court decision and keep the opportunity to discriminate against LGBTQ students and people in the school environment. So I want folks to really understand what is happening here is that the Supreme Court issued a sweeping, long-awaited ruling based on decades of precedent that should have readily been applied to Title IX in school settings. And because of the pushback from the right wing, that the benefits of that decision have yet to be fully realized across the country. And so it's really on us, not just in this moment, but in the years ahead, to hold people's feet to the fire so that the full equality of the law is realized. So what has happened since the Bostock decision is when the Biden administration came in, that they moved very quickly to try and apply the Bostock decision in the education context. And so in 2021, the US Department of Education issued a notice of interpretation saying that sexual orientation and gender identity are encompassed within Title IX's mandate of non-discrimination on the basis of sex. They then moved to update their regulations. Now, just as a quick primer, laws are passed by Congress, but the regulations are issued by agencies like the US Department of Education to provide guidance to stakeholders on how to implement those laws. And so the federal regulatory process takes some time because not only do the experts need to evaluate the case law and all of the potential research that may impact the policy, but they also need to go through a notice and comment process, which I'm sure all of you are familiar with in how to submit a regulatory comment. But what we saw in 2022 was that shortly after making the determination that Bostock should apply, the US Department of Education put forth a proposed rule to amend Title IX and really provide clarifications and updates that were needed to implement the Bostock decision and to ensure that the full breadth of Title IX's non-discrimination protections are felt by students across the board. That rule was finalized in April of this year. So it took nearly 2 years to get that rule finalized, but now a final rule has been issued. And that rule addresses 3 categories of protections. LGBTQ students, who we're going to talk about in significant detail today, but I want to make aware as well that the rule also applies to survivors of sexual violence by providing more robust procedural protections for those who have alleged sexual violence in education settings, as well as protections for pregnant and parenting students as well. And so something as straightforward as making sure that a school has a lactation room so that a student or even an educator who is pumping has access to a place that's not a bathroom stall to pump. So things that I think we all take for granted, but should be incorporated into the law and provided as protections, but also as requirements on schools to ensure. Now, when it comes to the LGBTQ provisions, there's several important pieces to discuss. First and foremost, the Title IX rule clarifies that the Title IX's prohibition on discrimination applies to sexual orientation and gender identity. It also states sex characteristics, which is important legal language for intersex students, as well as sex stereotypes. And I want to really underscore this, going back to that Pricewaterhouse versus Hopkins case, is that a cisgender straight student who decides not to dress consistent with the expectation of what societal expectations are of gender is still protected under the sex stereotyping scenario. So, for example, if a cisgender straight boy wants to wear an earring, he should be allowed to do so if the girls are. And making a sex-based distinction about earrings is impermissible. So, really making clear that we are not allowing sex-based distinctions that are discriminatory. A second big shift is that the language in Title IX has specifically been around sexual harassment. But as we know, particularly from our National School Climate Survey, there is a lot of harassment that happens beyond just sexual harassment, verbal harassment, physical harassment, and so on. And so there's been a shift in the language to move from sexual harassment to sex-based harassment. And that's particularly important for making sure that all of the scopes of prohibited conduct are included under Title IX. The big and I would say most controversial piece of the rule is around sex-separated spaces. And this goes back to our discussion about bathrooms, but it's not just limited to bathrooms. It's locker rooms, it's sex-separated classes like sex education and physical education, and it's overnight accommodations and school clubs and so on. And there are very few circumstances where a school is allowed to divide boys and girls in the first place. There should be no reason why there is a math class that is just for boys, right? And so the sex-separated spaces are limited moments, but where they exist, the rule is clear that schools cannot deny a student access to a sex-separated space that is consistent with their gender identity. And I think many of us are familiar with an incident that happened in Oklahoma in February of this year, where there was a student who was under state law forced to be in a bathroom that was inconsistent with their gender identity. And as a result, that student faced a physical attack from other students, and it resulted in that student's suicide the next day. And so we need to be mindful of how do we build inclusion by affirming transgender and non-binary students in their gender identity, especially when it comes to sex-separated spaces. The final piece is also particularly important as we move into an increasingly digital environment. It's that students should be, schools should be responsible for conduct that occurs outside of the exact school. So it's not just the four walls of the school, but if we think about buses, if we think about cyberbullying, that if a school is put on notice of discriminatory conduct, of harassment, they have an obligation to respond to create a safe learning environment. And a piece of that is also to create supportive measures. And so it's not just that all of a sudden, oh, there's harassment and we acknowledge it, but now you have to leave the school, but to think about supportive measures that can address the harassment and discriminatory conduct. And unfortunately, among LGBTQ students, we see disproportionate rates of students having to transfer classes and even transfer schools because they do not feel safe. About 11% of LGBTQ students have to transfer schools because they don't feel safe. And that is an unacceptable number, and one we have to work towards fixing. We go to the next slide. I want to highlight a few instances about how the US Department of Education in their Office for Civil Rights is interpreting Title IX and working to address discriminatory behavior. So first is an example I already mentioned, is a school was forced to revise their dress code because a male student was reprimanded for wearing an earring. So dress codes, and particularly gender dress codes, should be reevaluated to make sure that there's not sex-based distinctions. There's another example. Hopefully all of you following book bans have heard of this from last spring in Forsyth County, Georgia. A school district was investigated after failing to address student complaints about the process for removing LGBTQI-related books from the school library. And I think an important point to leave you all with is that it's not necessarily the book ban that got investigated in this case, but it was the failure of the school to address concerns about a hostile environment that came out of the book banning process. There were comments made by the school board members that were seen as discriminatory, and the school was on notice of concerns from the student, and they did not act. And that's the area where Title IX potentially comes into play. Again, Title IX does not govern book bans and curriculum, but when a school fails to address a hostile learning environment, that is an area where Title IX could come in. And another strong example of that is misgendering. And so we've got a case in California, and actually I should update this slide, another case from Wisconsin, where you have both a college and a K-12 school district that were found in violation of Title IX after failing to address repeated misgendering of a student. The California case was about staff repeatedly misgendering a student, and the Wisconsin case was about peers repeatedly misgendering a student. Now, it's important to note, and the Title IX rule is quite explicit, that a stray remark, a single instance of misgendering, does not necessarily violate Title IX, which is consistent with jurisprudence we see about racial epithets, religious epithets, and so on. However, when there is a pattern, when there is repeated misgendering, and the school has been put on notice, and they do not respond to the hostile learning environment, that raises the concern. So that's a piece to be mindful of, is that it's really about patterns, and it's about the school's response to ensure a safe learning environment for the impacted student. And then, of course, in the Oklahoma case as well, we have the instance I spoke about in February with Next Benedict, who was, again, forced by state law to be in a restroom inconsistent with his gender identity. And we know that that school district is currently being investigated for a potential Title IX violation as well. So these are a couple examples of how Title IX is already being interpreted with respect to LGBTQ students. Let's move to the next slide, because one of the big asterisks here is around school sports. And there's been a lot of back and forth around school sports, and I want to take a moment to acknowledge that the Title IX rule that was finalized in April of this year does not discuss school sports. The US Department of Education is actually conducting a second rulemaking. They've gone through the comment process, but they are still considering comments before they finalize the rule when it comes to the eligibility of transgender and non-binary students, as well as intersex students in school sports. GLSEN, our position, is that any student should be able to participate in a school sport consistent with their gender identity, same as access to bathrooms and locker rooms. However, the US Department of Education is taking their time to finalize this rulemaking. However, one of the pieces that we should be aware of is how this process is playing out in the courts. So even though the US Department of Education has not yet finalized its rulemaking on athletics, student athletes have brought their states and their school districts to court, alleging violations of both Title IX and the US Constitution's Equal Protection Clause. And there was a recent decision that came out the same week as the Title IX rule, actually, in the Fourth Circuit, finding that West Virginia's law that prohibited transgender students from participating on teams consistent with their gender identity violated both Title IX and the Constitution. So there is strong legal precedent that transgender, non-binary, and intersex athletes are protected by the law in accessing school sports, even though the US Department of Education has not yet finalized that rule. This is one of the areas where states have been most aggressive in regulating from an anti-trans perspective. 25 states have quote unquote sports bans that prohibit transgender, non-binary, and intersex athletes from participating on sports teams consistent with their gender identity. And so these sports bans remain the subject of the litigation, and the proposed rule from the US Department of Education, if finalized, would likely deem these categorical bans on trans, non-binary, and intersex athletes as inconsistent with Title IX. But all of that remains in process right now, and is not included in the April 2024 rule that has been issued so far. So want to just make sure that asterisk is addressed. Let's talk about implementation, because the final rule came out in April 2024 discussing the rights of LGBTQ students, survivors of sexual violence, and pregnant and parenting students. Under that rule, it is set to go into effect on August 1st of this year. And as of now, both the green and the yellow states on this map will be legally obligated to adhere to that rule on August 1st. As you would expect, folks who are opposed to the rule have decided to sue in court. And so there are 9 lawsuits from 26 states that are seeking to halt the Title IX rules. Many of these states, all of the 9 lawsuits, are challenging the gender identity provisions in the rule. Fewer of the lawsuits address parts related to survivors of sexual violence and pregnant and parenting students, but at the end of the day, at least one lawsuit is challenging all provisions within the rule. The red states have been issued injunctions already by federal courts. So as of now, when the rule goes into effect on August 1st, the red states do not necessarily have to comply with the Title IX rule. An important caveat to note is that the Kansas injunction, which was just granted last week on behalf of Moms for Liberty, actually includes a provision that allows Moms for Liberty and other organizations to demonstrate that other school districts outside of Kansas should be covered by the injunction. We are already hearing that Moms for Liberty is actually telling their members to go to their school board and say, just because I am a person from Moms for Liberty, you do not have to comply with Title IX. That is not the case. Moms for Liberty actually has to produce a list of school districts by July 15th to demonstrate that they have standing on behalf of those districts. So that piece is still being litigated. So if I were in a state that is not red on this map, I would still be telling my school district, you are legally obligated as of now to move forward with implementation by August 1st. The yellow states have pending lawsuits. So an injunction can still be granted in those states, and frankly, very well may be granted in those states before August 1st. But as of now, they do not yet have an injunction. So I hope that that map is helpful for folks understanding where their state and their schools are currently when it comes to the requirements that will be put upon them. But an important piece to note is that Title IX is the floor of what a school must do to support LGBTQ students. There is nothing in the law, nothing in these court opinions that says that a school district cannot go beyond Title IX to help their students. And that, I think, is the most compelling and convincing argument, is that you can go to your school board, regardless of what a court says, and say you need to do more to promote inclusion on behalf of kids in the district. We must continue to lift our voice and push those in power to be accountable for those in the community, especially those who are most marginalized. So do not feel, just because you're living in a red state, that you cannot carry a message forward. There is still work to be done, and no matter what is happening in the courts, school districts can still go above and beyond what they are legally required to do to make sure that their students are safe. Next slide. And there are a couple areas where even when the Title IX rule is in legal effect, that schools and states can go beyond. First is enumerating protections within anti-bullying policies. Title IX does not require schools to issue anti-bullying policies at all, and certainly does not require schools to issue anti-bullying policies that specifically state sexual orientation, gender identity, and other protected classes. And so that's an area where you can still work with your school district to issue a comprehensive anti-bullying policy. Another area where states can impact LGBTQ inclusion is around restrictions. And so we've talked about bathroom bans, but there are other local and state policies like pronoun bans, which prohibit school staff from recognizing a student's gender identity, their chosen name and pronouns, unless they have an amended birth certificate, as well as forced outing policies that we're starting to see pop up, where students who request a change to their gender identity, to their chosen name and pronouns, are now seeing a requirement on schools, on the teachers or administrators, who then have to actually inform the parents of the requested change. And all of these policies are coming up at both the state and the local level, and can infringe on a student's Title IX rights, not necessarily immediately, but as we discussed, through a pattern of behavior that a student might be experiencing either from their peers or from their school system in general. And then, of course, I want to be clear again that Title IX does not explicitly address curriculum or book bans, and that it does not infringe on existing laws like FERPA. And FERPA, for example, is a federal privacy law that for K-12 students grants a lot of rights to parents to amend and review student records, but may not necessarily grant those rights to students themselves. And so when we're dealing in the K-12 setting, there are students, of course, who are affirmed and supported by their parents who may be going through a change to their student records, but there are several students who may not yet be out to their parents or who may face rejection by their parents and may be in a different posture when it comes to being recognized by their school as consistent with their gender identity. Okay, let's talk about a couple steps that we can move forward. So first and foremost, in addition to the litigation, there are members of Congress who are opposed to the changes in Title IX. And those members of Congress are working tomorrow to overturn the new Title IX rules through something called the Congressional Review Act. Now, if you haven't heard this term, I want to make sure you understand what it means right away, is that the Congressional Review Act allows for a limited period of time Congress to overturn any regulation. If a Congressional Review Act resolution is passed, not only does it void the regulation, but it prohibits the agency from issuing a substantially similar rule in the future. And so if a Title IX Congressional Review Act resolution was passed, not only would it overturn the recent updates, but it would prohibit the US Department of Education from ever saying in the future that Title IX applies to LGBTQ students. And that would be horrific. Now, luckily, there's a limited window for the Congressional Review Act. And so that means right now that it has to happen this year for the Title IX rule. And so President Biden has a veto pen. So anything that happens in Congress to try and overturn the Congressional Review Act will not ultimately succeed. However, members of Congress will be voting tomorrow in the House of Representatives as to whether to pass this resolution. And so we urge you, and there's an action alert on that slide, pull it up now, start filling it out, and reach out to your member of Congress to urge them to vote against the Congressional Review Act, because that way you can express your support for the Title IX rule if they reject the Congressional Review Act resolution. Once it comes up in the House, it will likely pass the House as we know, but it will also likely come up in the coming weeks in the Senate. Now, I want you to understand this as well, because the Congressional Review Act applies to any federal regulation. So there's going to be a lot of pieces that we all care about, not just in education, but beyond, where there are Congressional Review Act resolutions in the coming months. And so I really want you to understand that dynamic and to speak out against it. Another piece that you can take, depending on your state, is to engage your state education agency, whether that's your state board of education, your state department of education, or so on. Because when you engage your state education agency, you can talk about general policies in the state, but also guidance that goes out to school districts. And that can be really important, especially if you're in one of those green or yellow states where there's an August 1st deadline to make sure that there is as much LGBTQ inclusion baked into Title IX implementation as possible. One of the big pieces that we're thinking about is around compliance measures. So can we get statewide data that talks about the rates of harassment faced by on the basis of sexual orientation and gender identity? And another big piece is that some schools can request exemptions from Title IX. And as parents, you should be able to go to a website and see which schools are exempted from compliance with federal law. But not every state has that. So pushing for publication and transparency of Title IX exemptions is another important ask at the state level. And then I think if we move to the next slide, we can talk about local engagement and going to our school boards. And that's particularly important because at the end of the day, even in a state where they may be hostile to Title IX implementation, there is opportunity to work with school boards on improving policies, whether it's something as simple as an anti-bullying policy that lists all of the protected categories, including sexual orientation and gender identity, to something more advanced, such as, data privacy of student records when it comes to transgender students, sex-separated space policies around bathroom access and sports teams, and so on. We have, both for engagement with the state and the local level, checklists, one-page checklists, and then much more thorough model policy resources that can help guide you in those conversations and provide examples of policies that your school board or your state education agency can simply adopt. And so we hope those are helpful resources to you. They are also all listed on our Title IX landing page, which is linked here as well. And of course, our email is there as well if you need any individualized assistance as you engage in conversations with your state and with your school board. Now, one final thing you can do if your school district does not care, and if your school district has a pattern of discriminatory behavior, particularly against an individual student or a group of students, is that the US Department of Education's Office for Civil Rights investigates complaints. And complaints can be submitted by anyone in the school district, even if you are not yourself the victim of the discriminatory behavior. There is an online intake form, and that intake form is shared on our Title IX landing page, along with some additional information about how to file a complaint. And making sure that the US Department of Education's Office for Civil Rights is aware of a school district that is not moving towards compliance and is frankly fostering a hostile learning environment for LGBTQ students, that is something that they can investigate and that they can take a deeper look into. And that complaint process is particularly effective at pointing out which policies contribute to a hostile learning environment and hopefully remedying them in the long term for future generations of students. Now, I know that was a lot of information. You have some immediate action items if you're going to weigh in on the Congressional Review Act, but also hopefully some longer term pieces where you can engage your state and your local decision makers as we push for at least the first wave of states to implement Title IX.
Yeah, we have a lot of questions. Someone asked if we could include fear of being outed for students, because that's also something that's big that I guess in their district that is affecting the kids. Brian?
Fear of being outed is not necessarily a protected category under Title IX, but it's how does it manifest? Mm-hmm. And going back to the beginning of the presentation, this was a piece where we saw that it contributes heavily to the underreporting of harassment, right? Mm-hmm. And so, nearly half of students who don't report are fearful of being outed to their parents, let alone, of course, being outed to the broader community. And so it's definitely a factor, but as a basis, it's not necessarily protected under Title IX, because keep in mind, Title IX is talking about discrimination and it's talking about harassment. And so, I think that fear needs to manifest in some form of discrimination or harassment to rise to a Title IX complaint. And so it goes back to patterns and it goes back to a hostile learning environment. So if you can make that connection, then you have a Title IX claim, or you have the ability to proceed with the Title IX claim. But the simple fear alone does not give rise to a claim.
And does Title IX apply to, and the requirements apply to private schools?
So it applies to schools that receive federal financial assistance, which is not going to be all private schools, but some of them. It's going to be most charter schools, and it's going to be all public schools. And an important point to raise as well, going back to the initial conversation of how broad Title IX is that it talks about no person. And so it's not limited to just students, but it can talk, you have rights as an educator, you have rights as a parent in the school. So, there are different manifestations of who is protected by Title IX. It is not just students.
Somebody asked if the Chevron SCOTUS decision will impact the final rule.
An excellent question. I full disclosure is I am not one of the litigators working on the 9 lawsuits here. I could go into a long conversation about Chevron. At the end of the day, I have full confidence that the agency took every step they needed to have a robust case for not just the Administrative Procedures Act, but for why these decisions have been made. And when it comes to the LGBTQ perspective in particular, keep in mind that there are decades of legal precedent around sex stereotyping that resulted in the Bostock decision in the first place. This is really, it is not necessarily new rights here. This is simply applying the Bostock decision to the education setting. And so it's consistent with the Supreme Court. But I think we're all clear-sighted on what is happening in the judiciary right now. And I think, can I take this moment, Julie, to talk a bit about Project 2025 as well, is that we're clear-sighted about what could happen in the coming months as well. Is that in Project 2025, there's a number of steps that would not only undo these Title IX protections, but they would also move to strip away the authority of the U.S. Department of Education to investigate claims of discrimination. They would allow the federal government to only enforce federal civil rights laws through litigation, which is a very slim minority of cases compared to the administrative complaint process that I was discussing earlier. I mean, of course, Project 2025 also calls for the complete elimination of the U.S. Department of Education, as well as slashing Title I funding and a number of other terrible things in the education space. And one final piece around Project 2025 as well is that it would create rights of action for parents who are aggrieved by processes in school and hold that to a higher judicial standard than victims of sex discrimination. This is, in my mind, quite unconscionable to provide a parental rights outing that is of even greater judicial precedence than victims of sex discrimination. And so, I think there's a lot on the table when it comes to Project 2025 that we need to be aware of.
Does a president have the ability to strip this away, basically?
Yes. And so, historically, the rulemaking process was intended to weather changes in presidential administrations. And again, the protections around LGBTQ students in particular flow from the Bostock decision, are rooted in decades of legal precedents, and we think should stand the test of time. That being said, we know it is at least the goal of Project 2025 to immediately reverse the Title IX rule and to use the rulemaking process to get rid of it.
One of the other questions that was in there was actually a series of questions that kind of surrounding, does Title IX allow separation of boys and girls in elementary school or high school for sex ed? And I think maybe somebody was thinking about how they used to do things. I don't know if they still do things this way. Does Title IX permit teaching of different lessons if the students are separated? And does Title IX allow for opting out of combined gender classes?
As I said, there are very few scenarios where sex-separated classes are allowed, and they are generally limited to sex ed and physical ed classes where there is contact in whatever sport is being played. The opt-out piece is not governed by Title IX law, but as we know in sex ed, states have different rules around opt-out, opt-in, and so that's more at the state level and not necessarily rooted in civil rights law as opposed to kind of state level curriculum law.
Well, and that kind of brings me to another question here. It says, can you detail what takes precedence when a state has LGBTQ protections by law, but there's an injunction against full implementation of Title IX?
That is an excellent question, Julie. And I think one piece that I will say is that over the next couple months, expect a really murky legal landscape as things are moving relatively quickly. The fundamental maxim is that federal law, which is Title IX, preempts state law. And so if things are fully implemented, we can see a scenario where there are now 13 states with the quote unquote bathroom ban laws. And if Title IX is legally enforceable in those states, the federal law will preempt the state law. So those 13 states will not be allowed to implement their bathroom ban law because they violate federal law. That being said, with injunctions and with ongoing litigation, what schools are legally obligated to follow will vary based on if there's an injunction or not. So, pay close attention to the legal landscape. But I think on top of that too, don't be limited by the legal landscape, because we should not simply oppose bathroom ban laws because it's against federal law, but because it's also wrong in principle. And so we should be pushing our school districts in particular to, take what steps they can to not be in compliance with the state law. We should, push for changes in the state law. We should push for inclusion across the board, regardless of what is legally required.
Someone asked if grandparents are allowed to lodge complaints. And I'm going to, okay.
Yeah, in the US Department of Education's Office for Civil Rights, anyone can file a complaint, even if you are not the direct victim of the harassment or discrimination.
And it says, is it a possibility to do a public records request to calculate the number of instances that bullying was based on sexual orientation and gender identity?
Yes, and I think that's an important point because we face such a dearth of data when it comes to the cases that are happening. So there's something called the Civil Rights Data Collection that happens at the federal level and requires school districts to report out certain instances of harassment and bullying. But the way that that data collection is handled doesn't necessarily break out cases on the basis of gender identity. We get sexual orientation and we get sex data, but we can't separate sex and gender identity claims. And so, that's a conversation to be having at the school level and at the state level of how can we get stronger data about what exists.
Is the majority of the upset, and I think the answer is probably yes to this, with trans women or men transitioning into women or to women in sports? Is that really, because I don't ever see it being talked about the other way around, and I think that was what the person was asking.
Yeah, we have seen a disproportionate focus on essentially women's sports in particular, and a piece of that is a long history, and we've seen it in the race and racism context as well, of a long history of trying to protect and use white women in a way to exacerbate division. And we cannot fall for it. It's not just trans, non-binary, and intersex students who are impacted by sports bans. We have seen a disproportionate impact on cisgender girls of color. Because when you submit students to certain expectations of femininity, when you require students to produce documents or open them up to essentially questions from their peers and from their coaches, that's going to impact any student that does not conform with everyone's expectation of femininity. And so it is a really unfortunate dynamic. There have been some state legislators who have called for sex testing, essentially physical exams of athletes. And that's in this country, and particularly when we're talking about elementary and secondary school sports, completely unacceptable. And so, you know, it's really important to recognize that there is a spillover effect beyond the LGBTQ community when it comes to athletics.
Well, thank you so much, Brian. Julie, I'm going to kick it back to you.
Okay, I know that we're at time. There was one question that came in from the signups that I did want to ask. How does Title IX, or does it have any impact on staff? So like a teacher who wants to wear a rainbow pin to show she's an ally or a safe space and is told she can't do that. Is there any protection for that in Title IX, or is that completely separate and we're just really talking pattern and practice in the school?
Title IX does cover staff. And so if an educator is facing a pattern of discrimination, it will apply to them. Some pieces like wearing a rainbow pin or safe space stickers, you know, it's not yet adjudicated under Title IX. And, you know, there's a few other remedies that may exist. So Title VII, for example, for a wrongful termination, but also that really crosses over into First Amendment territory as well.
Just want to say thank you so much to Brian for spending this hour with us, sharing all this really critical information. And we appreciate all of you for coming. And we hope to see you soon at the next event on Thursday. So rally your squad. All right. Good night, everybody.